I call Louise Upston.
Thank you, Mr Speaker. I'm pleased to stand to speak on the Public Works offer back of compensation for acquired land amendment bill in the name of Te Ururoa Flavel. And I think, as other speakers before me have said this afternoon, the motive for this particular bill is worthy, but in practice, the further we got into this bill as a select committee, the more troubling it became. And there were a number of submitters that were in support of the motive or the intent behind the bill, Mr Speaker, but raised serious concerns from a wide range of quarters, whether it was from the City Council, such as Manukau City Council, Wellington City Council, groups such as Federated Farmers, airports such as the Auckland City Airport, and also groups like Vector. So what I thought I would do, Mr Speaker, is just talk about some of the challenges that have arisen as a result of the submissions, to just explain in a little bit more detail why this legislation won't really work, and that's why the National Party won't be supporting it in its second reading, and in fact the Select Committee as a whole reported back that it recommended that this bill not be passed. So there's a couple of issues or challenges. One is the retrospective nature of the legislation, the definition of original use, unintended consequences that arise, and also the impact on future land use. So if we look first at unintended consequences, I thought I would use an example that Vector, who were opposing the legislation, opposing the bill, brought forward, because it's not just Māori land that's affected, it's all land, Mr Speaker. And there could be a situation where a piece of land was subject to discussions under the Public Work Act that was actually then acquired voluntarily through a sale and purchase agreement that would then be subject to this legislation. So no matter how the land was acquired, it would be subject to the offer back requirements. And one of the issues is, even if the land is not required for the original purpose, it may be required for other public works, and I'll give a couple of examples of that. And one of the problems then becomes, in a situation where there's a piece of land that's currently used for a public work, there could be more than one public works utilising that site. Co-location, Mr Speaker, is more prevalent these days, so the problem becomes compounded. In terms of the retrospective nature of this legislation, it would create significant expense both for central government and for local government. It would be incredibly inefficient to have to offer back land to the original owner, assuming you could track them down. And then, if the land was still being used for a current public work, if not even the original public work, that organisation, whether a central or local government, would have to go through the process of then repurchasing that piece of land, which is very bureaucratic and cumbersome, and of course not at all what this current government is interested in when we are about getting rid of red tape and getting rid of bureaucracy. So then it comes to the issue of original use, Mr Speaker. Now again, this government is spending billions of dollars on infrastructure, unclogging the arteries of our country, and I'm not going to go into the matters of unclogging arteries like the Honourable Tau Hanare has already described earlier in the House today. But I do want to give a simple example of how the original use can change over time. So if you think back, there might have been some land that was purchased, let's say, for a post office or a manual telephone exchange. Over time, it's gone from a post office to a telecom exchange to perhaps a cabinet on the side of a road, now to a fibre optic cable under the ground. So the argument that the submitters raised, Mr Speaker, is that fibre optic cable the original purpose for which that land was acquired? And if you were looking at it from a pure perspective, you would argue no. If you look at it from a pragmatic perspective, you would have to argue that it does. And that's why the original use definition creates significant problems. If we take that argument forward, Mr Speaker, we then look at the impact on the future land use. And we'll use the example of an airport. So the airport clearly needs room in the future to expand. If you're planning an airport that's a 50-year horizon, not a 5-year horizon. So one of the airports that came to submit to us had said that they had significant blocks of land that were for the purpose of an airport, but currently they didn't need that land, but they would need it in the future. So all of a sudden you would have a problem if this bill were to pass, that airport would have to offer back the land that they were not currently using for an airport but needed to in the future, and then hope, which is fairly unlikely, that in the future when they did need the land they'd be able to purchase it back, which is a bit ridiculous. So those are some of the complicating factors with this proposed bill. Another unintended consequence of the bill was raised by Wellington City Council, and it gives another example of this difficulty around the public work and the use of the land. In this instance that they quoted, there's a paper road that's not used for a road, but is used for the very important purpose of flood control. So would we expect under this piece of legislation that the Wellington City Council would have to offer back the land that they so desperately need for flood control because it's not being used as a road? So these are some numerous examples of how difficult this particular legislation was, the deeper we delved into it. And I must say again that the intention of the bill was great. I commend Te Ururoa Flavel for bringing the bill to the House and getting it through the Select Committee process. And he, as well as any of the Select Committee members, recognises the difficulty with actually taking it further. I recognise that there are some difficulties and some problems that need to be solved, and some of the submitters also said that, the Public Works needs further attention. Mr Speaker, we are actually, as this government, looking at aspects of the Public Works Act when we do our Phase 2 reform of the Resource Management Act. The first phase was incredibly successful, and it's great looking at the next round of reform, part of which will incorporate the Public Works Act. So we do recognise on this side of the House there are some issues. Unfortunately, Mr Speaker, this bill doesn't fix those issues, and I look forward to being part of the committee working on the second phase of the RMA to pick up some of the issues with the Public Works Act. Thank you, Mr Speaker.
I call Phil Twyford.